If you own a firearm in the United States, you were told the Supreme Court settled the issue in 2022. You were told Bruen changed everything. You were told unconstitutional gun laws were finished. But here we are, years later, and in many states, gun restrictions are expanding, not shrinking. Carry permits are harder to use, locations are more restricted, and new penalties keep appearing. Today, I'm going to explain how that's possible without the Supreme Court reversing itself, why states are openly defying the spirit of Bruen, and how this quiet legal war is shaping gun rights in 2025 and beyond. This is not hype. This is how the system actually works. Watch until the end, because the final section explains why most gun owners lose even when the Constitution is on their side. Law 1. The Bruen Framework. Let's start with the foundation. The Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen did not declare every gun law unconstitutional. It did something more precise and more dangerous to lawmakers. The court rejected interest balancing, the idea that states can weigh public safety against constitutional rights. Instead, it imposed a historical test. If the government restricts the right to keep and bear arms, it must prove that the restriction is consistent with the nation's historical tradition of firearm regulation. No modern policy arguments, no studies, no emergency claims, text, history, and tradition only. That ruling was seismic. Entire categories of modern gun control suddenly rested on thin historical ground. Legislators knew it, attorneys general knew it, and immediately after Bruen, states faced a choice: comply or adapt. Most chose adaptation. Law 2. Legislative evasion. After Bruen, many expected states to repeal may issue, carry laws outright. Instead, legislatures passed replacement laws with new names and new structures while preserving the same outcome. Discretion didn't disappear, it moved. Instead of asking whether an applicant had proper cause, states created lengthy training mandates, subjective character evaluations, expansive documentation requirements, and administrative delays. On paper, these were shall issue. In practice, they remained restrictive. Courts now have to analyze each new provision separately, which takes years. During that time, the laws stay active. This is not accidental. It is procedural warfare. Law 3. Redefining where rights exist. Bruen acknowledged that certain sensitive places could be restricted, but only those with historical analogs, like courthouses and legislative chambers. States seized that language and stretched it to the breaking point. Entire categories of everyday locations were declared sensitive: public transportation, entertainment venues, parks, parking lots, government buildings, and, in some states, any private property unless the owner explicitly opted in. The effect is simple. You can carry, but almost nowhere you actually go. Courts are divided. Some have blocked these laws, others have allowed them to stand temporarily. The Supreme Court has not yet stepped in to draw a firm line. So enforcement continues. Law 4. Enforcement does not wait for final rulings. Here's a reality most people don't understand. Police enforce statutes, not court predictions. If a law is on the books, it is enforced even if it is likely unconstitutional, even if a lower court has ruled against it. Appeals pause injunctions. Temporary stays revive enforcement. And while lawyers argue, citizens get arrested. By the time a law is finally struck down, years may have passed. Charges may be dismissed, but the damage, financial, emotional, professional, is already done. This is why winning a gun case often feels like losing. Law 5. Time is the weapon. States know something critical. Litigation is slow, and compliance is optional until the end. Governments can enforce a law for years before the final ruling arrives. Even if they lose, the penalty is usually just repeal, not punishment. There is no refund for lost rights. For the state, delay is cheap. For the individual, delay is devastating. This asymmetry encourages aggressive legislation. States are betting that most gun owners will comply quietly rather than risk becoming the test case. So far, that bet has paid off. Law 6, narrowing Bruen without overruling it. Some courts have adopted an extremely narrow view of what qualifies as historical tradition. They demand nearly identical regulations from the 18th or 19th century, dismissing broader analogs. Others allow governments to cherry-pick obscure or short-lived historical laws to justify sweeping modern restrictions. This creates wildly inconsistent outcomes across jurisdictions. The same law may be blocked in one circuit and upheld in another. Until the Supreme Court intervenes again, that inconsistency persists. And inconsistency favors enforcement. Law 7. No immediate consequences. States that pass unconstitutional gun laws rarely face direct penalties. Officials are not personally liable. Budgets absorb litigation costs. Political careers often benefit from fighting gun owners, even if the law eventually fails. There is little incentive to comply voluntarily. In fact, there is often more political reward in defiance than obedience. This is why Bruen compliance is uneven and often reluctant. Law 8. Supreme Court rulings are not self-executing. A Supreme Court decision sets a standard. It does not rewrite statutes automatically. Legislatures must act. Lower courts must interpret. Enforcement agencies must adjust. And all of that takes time, sometimes decades. Brown v's Board of Education did not desegregate schools overnight. Miranda did not end unlawful interrogations instantly. Bruen is no different. Rights exist on paper long before they exist in practice. Law 9. Legal uncertainty is the danger. For gun owners, the current environment is risky. Laws are changing faster than court rulings. Guidance is inconsistent. What is legal in one jurisdiction may be criminal in another, even after Bruen. This uncertainty chills lawful behavior. People avoid carrying, avoid traveling, avoid exercising rights not because the Constitution changed, but because enforcement hasn't caught up. That chilling effect is itself a form of control. Law 10. The Supreme Court will be forced to act again. Multiple Bruen-related cases are moving upward right now. Sensitive place laws permit delays, carry restrictions. The court will eventually be asked to clarify how far states can go, but the court moves deliberately, and it hears only a handful of cases each term. Until then, states will keep pushing boundaries because they can. Bruen was a turning point, but not an ending. It exposed the weakness of modern gun control, and states responded by testing how long they could resist. Rights don't vanish overnight. They erode through delay, complexity, and uncertainty. If you think a single court ruling permanently protects you, history says otherwise. The fight now is not about what the Constitution says. It's about whether states will be forced to obey it. If you want to understand that fight as it unfolds, hit that like and subscribe button and help us reach our amazing 1,000 subscriber milestone. Every single subscriber matters. Your support is what makes this journey possible, because the next ruling could finally draw the line or prove that defiance still works.